All right, you may be seated. All right, we're back in session. The court has called up the matter of State versus Timothy Ferriter and Tracy Ferriter. Appearance of the counsel, please.
On behalf of the state, Brianna Coakley.
On behalf of Tim Ferriter, Priya Marat,
Jennifer Marshall, on behalf of Tracy Ferriter.
Kirsten Herndon, legal aid on behalf of the child.
Okay. All right, so we have a number of matters to be heard by the court this morning. Let me just address the first one that I think I've been advised that there's an agreement. That's the motion to sever the co-defendants. Is there agreement on that?
Yes, sir.
All right, so in light of the fact that the state has agreed to the defendant Timothy Ferriter's motion to sever, the court will grant that motion, which brings us to the next question of which case it is going to go to trial on the 29th.
Your Honor, I need about a week to make a final determination, but I expect it to be Tim.
Are you expected to be 10? Okay, all right. So just let the court know, let the defense counsel know as soon as the state's made a decision on that. And once the decision is made, I want you to come back in front of me so that I can also go ahead and get Tracy Ferriter's case set on the docket as well, because it's a large panel jury selection.
Well, I think it's a large or panel, but the fact that they're severed significantly reduces the number of jurors that we can.
Okay, so then we can put that on.
We can probably do like 60 to 70.
If you can do 60 or 70, we put that on the normal docket. It can be scheduled fairly promptly.
Yeah.
We can discuss this, I think, at the end. I agree with the state that it will not need to be as large of a panel because obviously there will be 12 peremptories between us, but because of the media attention this case has had, my concern is that 70 won't get us, and it is
Well,
allegations.
it's not going to be an issue for the first one going on.
Oh, understood, because we already did the big
It's
panel.
already a large panel.
I apologize, I
It would
understand.
only be an issue for the second trial as to how many jurors you need. If you are going to need 100, then we need to schedule that as early in advance as possible because you're typically looking at a lead time of 3 to 6 months as to when I can get you, because we want this to be number one when it goes, so that's a lead time of at least 3 to 6 months. All right, okay, so it won't be an issue though for the first one, because we're already in the proper track for that case.
Okay, thank you.
All right, so nothing further for the court to do on the motion to sever. So that is granted and cases will be severed and the state will let the court know which case is going to trial on September 29th. Okay, so I don't care what we deal with next. We can deal with the notice of production from non-party and the objection or the waivers rule. Those are the only two other issues to be
For today.
addressed for today. Okay, so Ms. Murad, do you want to deal with the notice of production? Is that yours?
It's the state's objection, but the request is mine, so I'm happy to begin.
So let's start out with your request, and then I'll hear the objection. And I want you to also address for me, because my recollection is that I kind of addressed some of the issues that are raised in this previously, and I think I ruled in a way that was against the defendant's position on this in terms of the disclosure. But you can refresh me, and then I'm sure I'll recall it.
Sure, Judge. I filed a notice of non-party production for specifically behavioral, medical, and educational records for the child RF from the dates he was at whatever the facility I asked for, so it's Suncoast and Sandy Pines, and it specifically stated these records should not include any communications between the child and any treating mental health professionals or any mental health diagnoses. At the last hearing, we asked for essentially medical and psychiatric records, and the court denied that request. And I believe the court's ruling was primarily based on the psychotherapist patient privilege, and the court, I believe, also cited Marcy's law and confidentiality, which I have a position on that as it relates to this. I actually specifically asked the court at the end of that hearing what the court would decide as to behavioral records, and the reason is, if my memory is correct, and I actually do have the tape of the hearing should we need to listen to it, the court stated that psychiatric records the court considers is very unique compared to just a medical record or behavioral records. And the court stated that the defense could file this because you would be, that perhaps the threshold is not as stringent for the records that we are asking for now, as opposed to those covered under psychotherapist patient privilege, and also that the court's concern as far as the materiality is the fact that we are asking for records after the surrender to the Department of Children and Families or after the removal. So that is my understanding of what the court's prior ruling was.
That's generally consistent with my recollection.
Okay. And so I have received the objections from both the state and Ms. Herndon. They seem to be the same. So Ms. Herndon provided case law to the court that I don't believe is applicable. The first set of case law I think is related to Hunter hearings, which I don't believe is applicable here. Hunter is a very specific case for the state having a compelling interest to get the defendant's records, particularly, I don't think it has to be DUI cases, but that's where we see it the most.
But before you dispense with that so quickly, I read all of those cases, and although they might not be, on point factually, the legal argument, the underpinning was the defendant's some of them I think dealt with victim, but the confidentiality that ascribes to the medical records of the defendant. Now, they went beyond the psychotherapist privilege documents, and so to me, potentially give greater support that even the medical records are protected because of their confidentiality. So address that, because I agree with your point, but the underlying legal analysis, it seems to me, is somewhat, it applies.
Sure, so I think that's right. I think what's interesting is I have never in my career won a Hunter hearing. The state always gets the records that they request of my client because it is material to their case. And so I think that is just the question of whether or not there's enough materiality here, and the state mentioned that as their objection.
So here's the question I have for you, and why I found the cases somewhat interesting. I was a little surprised that, at least in some of the cases where the appellate court looked at what's required of the state to show materiality, and then, in other words, they just can't rely on argument. In those cases, the appellate courts required that they provide evidence, whether it's the probable cause affidavit, the arrest report, or something like that. So that struck in me a question of, well, if the defendant is the one seeking these documents and they're required to establish materiality, are they also then required to submit evidence to establish the materiality? That was the nugget that I got from that review of the cases.
So I have some of that evidence. Where it's sort of a chicken and egg situation in this case because we don't have access to the records of the child, which would provide us with the evidence that we need. So I'll sort of make this twofold as to materiality. We have subpoenaed the ChildNet records for the child in this case. And after he was at one facility, he then moved to a facility called Suncoast. Suncoast then had to remove him, and he went to the facility that he is at now. I know from the I know from those records, and I didn't print it out, Your Honor, because it's 2,000 pages of records, but I'm happy to email to the state and the court the relevant portions. When he was leaving Suncoast, and there were efforts to place him, there were several facilities that would not accept this child. And the reason that is material to the defense, I'll sort of explain one by one. So Rolling Hills declined due to, and I'm never going to be able to say these medical terms correctly, but essentially a lack of control for defecation and urine.
So I'm going to object that these are things that come from confidential juvenile proceedings.
I don't believe they are, Judge. These are subpoenaed records from ChildNet. Yes, we subpoenaed them in the dependency case, but that doesn't make them confidential. And also, how are we supposed to have...
And how do you get to that point? Because juvenile proceedings are by their definition confidential, so it seems to me that anything obtained in that process would have had to have been obtained independent of that process to remove the confidentiality that would normally attach to it by virtue of being part of the juvenile proceeding.
So Judge, I think, and I'm just looking up a memorandum that actually Ms. Marshall did on this issue, so I'm pulling that up so that I can provide the court with the case law on that issue, on that specific question. What I will say is this: how are we supposed to present evidence to the court if we're barred from presenting any evidence that is
And
material?
quite candidly, I don't know the answer to that because we all are operating within the realm of what the law says applies to the protection of proceedings that are juvenile, and the law protects those as confidential. We also are operating within the realm of patient psychotherapist privilege and potential confidentiality of medical records. So those create difficulties, but they're difficulties that exist because the law says that there are thresholds and hurdles that have to be met or overcome.
So here's my question. We are deposing this, and this might sort of speed up the hearing today. We are deposing the child this afternoon.
Right.
And we could just ask these questions regarding behavior of the child. And I don't know if the state and Ms. Herndon intend on objecting to that, such that we would have to come back to the court. But once we depose the child, we may have the evidence we need to then say, Judge, here's a deposition. We know that this exists. Part of the issue is, right now, that we have to present a defense in this case. And I understand the state's position that this should not be admissible.
But I'm sorry to interrupt, but
Yes.
I want you to focus on what is key to me. I don't know that the state's taking the position that there isn't some way that you couldn't get records that existed prior to the incident. But their position, I think, is because these are records of medical and potentially psychiatric treatment that occurred post-incident, post-arrest, that they're not relevant and therefore you can't show materiality. That's their argument, I think. So.
But how can I show materiality to the court without talking about the specifics? And so what I'm saying is, when we depose the child this afternoon, that could give me access to evidence I can provide the court in the form of a depo transcript of what the child is saying. What I don't know is if the state and Ms. Herndon are going to object in that deposition such that we then have to come back to the court, or they're going to seek a protective order as to asking, and we're not going to ask about what have you told your psychiatrist, what have you said, but have you gotten in trouble while you've been in these facilities? Why? What behaviors were you?
Why is him getting in trouble after the alleged incident while he's in furtherance of his treatment? Why is that even relevant to the charges against your client in this case?
For a few reasons. In this case, the state has videos of the child in the room, and he is utilizing a bucket to use the bathroom. Part of the reason for that, and it is evidence that doesn't look good for the defense candidly, is because this child has a history of utilizing the bathroom in his room. How are we supposed to corroborate that by anybody other than our clients, who knows if the jury will believe or not, without independent evidence that there are doctors that have identified this?
But isn't that very, very close to improper character type evidence that you're trying to prove up an element of your defense in this particular instance by showing that he's engaged in the continuing conduct that led to whatever actions your client took with respect to him?
No, it only becomes relevant, for instance, if one of the defendants is on the stand and the state says, well, you're the only person who's a witness to this. We don't have any medical records. We don't have any evidence of this. We need this to be able to rebut that line of questioning. There is, in fact, evidence, corroborating evidence as happens. Is it admissible in the case in chief? That's a completely different question. But it is relevant, it can become relevant, and there is a mechanism for you to review those records to determine whether or not they're relevant. I would also add that these, when we try to give you evidence of what these acts are, there's an immediate objection. And the problem is that these records were obtained when the parents still had intact parental rights. They had the right to those records legally, they possessed those records. So there is not an issue. If this is a juvenile case, it's not admissible.
All right, so let me make a rule. I'm going to sustain the objection to the extent that the information was obtained by and through the juvenile proceeding. I conclude that it remains confidential and cannot be disclosed. However, to the extent as you're arguing, Ms. Marshall, your clients are in possession of documents independent of the juvenile proceeding, then that would be a separate issue, and I would have to address that separately because that would not fall under the penumbra of my ruling that the information would be confidential because it came through the juvenile proceeding. But if your clients have copies and they didn't get it through the juvenile proceedings, then it may be something that they can utilize, but the victim in this case would still have the privileges under the law of psychotherapist patient privilege, I believe, and possibly medical confidentiality. That's my initial reaction, and you may have something that says, no, that doesn't apply because these were obtained by your clients as legal guardians, and therefore they're entitled to know it. So I don't know the answer to that legally. I haven't seen any cases on it, but I would think that there's still the privilege issue I'd have to address and see whether it's applicable.
What I'm not understanding regarding the state's objection, I was reading the case that Ms. Coakley cited in her objection, Jackson versus Kelly, that Judge Kelly actually was the trial court judge on this. And the primary issue in that case was that the defense issued an ex parte subpoena, and the court found that the defense cannot do that. That's obviously not the case here. The state's well aware of what we're doing. But then came the question of materiality. And in that case, it says, thus, if necessary to avoid revealing privileged communication or protected work product, the petitioner could ask the trial court to review his showing of materiality for the additional discovery in camera. So I still believe that there is a way for the court to determine what materials the court feels is appropriate for the defense to get. The court could even issue an order that once the defense gets the materials, nothing can be disclosed to the public, or not that we would do that, but we're obviously in a public hearing right now, until there's a ruling by the court on what is admissible at trial. It is not our intention to, sit here and have a bajillion hearings talking about what this child has done. We just want to be able to defend our clients.
So, segue into the issue that you also mentioned, Marcy's Law and harassment and protections that victims are entitled to under that, how that doesn't provide protection to the victim in this case.
I was reviewing the victim's Bill of Rights this morning, and I think that the only two that would apply in this case were subsection 2 and subsection 5. Subsection 2 states the right to be free from intimidation, harassment, and abuse. Subsection 5 says the right to prevent the disclosure of information or records that could be used to locate or harass the victim or victim's family. I don't believe that that's appropriate here. Or which could disclose confidential or privileged information of the victim. So I understand, however, how is it confidential?
So if we depose this child this afternoon and say, hey, have you gotten in trouble at this facility? What happened? What did you do? That's not privilege, that's just conduct. It may be inadmissible at trial, and the state will probably file a motion in limine asking the court to exclude it. That I understand. But right now, we're completely blocked. And if we depose that child and he says something, we have no ability to see whether or not it's credible. We have no access to the witnesses. We have no ability to look at the records to see if the child is being honest. And credibility is always an issue, and it has nothing to do with whether that was pre-DCF surrender or post. Credibility is relevant at the time that the person testifies, and this child has to testify in this case. So at some point, we're sort of like talking in circles a little bit, but we have to be able to investigate this.
So let me push back on that a little bit. One, the question that you've posed, I don't think, to me, sounds facially improper. Just because someone is in a medical or psychiatric facility doesn't mean that everything that occurs in that facility is necessarily confidential or protected. I think conduct and actions is something that could be reached at for purposes of whether they in fact occurred or not. But what you would clearly not be able to get into was whether, what were your diagnoses, what was your treatment protocol, what were your conversations with your doctors or your psychotherapists. Those would be clearly, in my mind, not reachable. But it doesn't strike me that if you're simply asking a question, for instance, with the bathroom issue, whether you've used a bucket where you are now, I mean, it's a matter of discovery that it might be something that you could get at. And I don't know, at least until I hear from the state's position, they may have a counter argument. It doesn't strike me as facially objectionable to that type of information.
I agree. So then my argument regarding the subpoena, the documents that we're requesting in subpoena is twofold. If there is no privilege as to that information, which is what we're asking for, what objection does the state have to us getting those records and the court reviewing them ex parte?
Because the records, unlike getting the testimony from the victim or any witness as to what conduct he's engaged in or she's engaged in at a facility, that is different than getting the records themselves, which reflect the mental impressions, thoughts, and conclusions of doctors and treating physicians and psychiatrists and everything.
But if the court reviewed them in camera, all of that could be redacted. The second issue is we don't know if the child is being honest with us. There is a history in this case of him being dishonest with the police. We have it on the CPT interviews. So if the child tells us something, then we have no ability, none, to figure out what actually happened, right? We just have to take the child's word for it. We have no ability if we don't have access to
Give me a for example on that, because the things that's going to be most relevant, I think, is the facts leading up to the alleged incident in this case and what occurred in the home. So give me an example of where you couldn't challenge the veracity of the victim when you call that person to testify.
Sure. So if the alleged victim testifies or we depose him about any incidents that have happened. So for example, Judge, and these are records that we have independently obtained, the parents sent a medical release to the facilities, we received it back. So this is not obtained throughout the process of the juvenile proceedings.
The juvenile
Right,
proceedings,
right.
yeah.
So in the CPT interview, the child advised the police that he was, first off, the officer asked him, do you know the difference between a truth and a lie? Like they often do, and then asked him about, if I told you this wall was blue, what would you say? And the child said, well, that's up to perception. And then had a conversation about how he met an 8-foot South African man who either gave him money or stole his money, I'm not sure, under a bridge. We know that that's not true. We know that while he's been at different facilities, there have been sort of allegations that are unclear of him running into traffic, him saying he's been hit by a car.
As all this has to do with the dependency case, his placement in these post removal was as part of the dependency
All right,
case.
so that objection is overruled because this is still going to credibility. For purposes of arguing credibility of the victim, if he testifies in this case, I don't know what the limits of the inquiry are going to be yet in terms of attacking credibility. So for purposes of this argument, I'm going to allow you to continue with your argument.
Thank you, Judge. So we know between things that we've, medical records that we've seen, videos that we've seen, there are ring videos that the state provided of the family, of the child lying about participating in an entire mock trial. We know that at one point, and we know this from interviews.
Okay, but that stuff, that it sounds to me like you have a ready source of evidence that you can establish the lack of credibility of the victim child that's testifying.
But I don't think that's the standard, Judge. Credibility is always an issue, and if there is sort of consistent over time and continuing issues with the child's credibility, I think the defense has the right to explore that. The court may find that we don't have the right to talk about it in trial, but I think we do for impeachment purposes.
But even in terms of attacking the credibility of a witness, you're still going to be limited to what is admissible evidence and what is proper discovery. And the law sets the parameters of that, not me. So, I mean, there may be great stuff in the victim's, psychotherapist patient records that would be great for a defense attorney to have. But the law says you can't really get at that. That's almost sacrosanct of being protected.
One of the issues in this case is an allegation of physical abuse. The child has testified and has given statements that no one was witness to this physical abuse. It was just between him and his father. No one else heard it, no one else saw it. We have reason to believe that the child has made allegations of physical abuse while in various facilities that turned out to be instances of self-harm. This is behavior that is directly relevant to the allegations he's making in this case. They are directly relevant to impeachment of the child. If there's a pattern
Let me stop you there,
behavior-
Ms. Marshall. How is a statement in a facility of physical abuse that resulted or was caused by his own self-harm, how is that indicative or not as to whether his allegations as to his parents physically abusing him are true or not? To me, it's apples and oranges. Why isn't it apples and oranges?
It's a pattern of making a statement as to, it is so very similar as to establish a pattern and an MO, if you will. It's almost reverse Williams rule if you look at it in that way, is that there is a pattern of behavior of making an accusation of physical abuse, self-harming, accusing an adult of doing it, and then saying, I was abused.
And that strikes me as classic improper character evidence. Because he's a liar, he must have lied in this instance. And again, the law, not Judge Coates, the law says that you can't bring improper character evidence into a trial unless it's, the issues raised by the state.
To determine pre-trial, we don't even have a chance right now, right? We don't even have an opportunity to have a proper hearing because we don't have any evidence.
Well, I'm trying to give you a proper
No,
hearing.
no, no, I don't mean for this judge, but I mean when the court is determining what's admissible at trial or not, or what the defense can get into, you know, the scope of discovery, as the court knows, I mean, this is an obvious statement, is much larger than the
Yeah.
scope of what actually comes in at trial. And the court can, the records can be viewed ex parte, the court can redact anything that the court believes that the defense should not have access to. The court could issue an order saying that no party is permitted to disseminate the records, they have to be kept internal until the court makes a ruling, which can also be done ex parte in camera, regarding what is admissible at trial. So we don't have to put this child in that position. We can do it ex parte, so that way we're able to sort of determine what the defense can actually admit at trial. But right now, we don't even have a shot. We have no ability to engage in that discovery. And regardless of what the court does regarding the records, I would like to have a discussion with the state and the court regarding if they're going to object if we ask those questions in the deposition this afternoon, because it's going to continue to delay the case, and I'm concerned that there's going to be objections and privileges raised that we don't expect, and then we're going to have to come back here to get rulings on that. So I'll just say that as a separate matter,
All right. Anything else, Ms. Murad?
not as to this issue.
All right, Ms. Marshall, anything else from you?
No, Your Honor.
All right, thank you. Let me hear from the state, and then Ms. Herndon, I'll hear from you in behalf of the victim's position.
And Your Honor, Ms. Herndon provided to the court and the state would also rely upon those cases, because we do think that they're pertinent. They're Knight versus State, which is 335 Southern 3rd, 190, 2022, which is a 5th DCA case. Leica versus State, which is 283 Southern 3rd, 853, 2019, a 2nd DCA case. Cerrone versus State, 823 Southern 2nd, 150, which is from 2002 and is a 5th DCA case, as well as SP versus Vecchio, which is 162 Southern 3rd, 75, a 4th DCA case from 2014. The first three have to do with a Hunter hearing, but the analysis is what is relevant here, because it's the same privacy analysis for a defendant as it would be for a victim. There is a general constitutional right to privacy, and more specifically, the people of Florida enacted a specific constitutional right for privacy as it applies to victims that was which was memorialized as Marcy's Law. The legal analysis from Hunter is the same, that there is a high level of protection for confidential medical records, and before even the state, who has a higher investigative ability than the defense, is able to reach those, we have to establish materiality of the records at an evidentiary hearing where we bear an evidentiary burden. Vecchio has to do with the objection to a victim's records and found a high standard because of the huge issue and the obvious harm that occurs through the disclosure of a child's victim or medical records. Now, the defense says, well, we don't know what's in them, so we can't, this isn't fair. And the courts have dealt with that. The case that has to do with that is State versus Stevens. It's cited in the state's response, Your Honor. State versus Stevens had to do with a subpoena ducis tecum for a investigatory plan, the operational plan, for a law enforcement operational plan related to a sting operation. The court there did the analysis and said that the defendant was not entitled to law enforcement's operational plan because he advanced nothing more than a mere possibility that the operational plan might aid in his defense. And it did acknowledge that it is difficult for the defense to overcome that burden when they don't know what it contains, but the court can't rely upon speculation that there might be something useful, and they just need to take a look in order to establish the usefulness. And then the state also relied upon Jackson versus State, which is 202 Southern 3rd, 97. It's a 4th DCA case. That case stands for the proposition. The issue there was whether or not they could do a secret subpoena ducis tecum. But ultimately, the reason that I cited it for this purpose is because the court concluded that the defendant's subpoena power is not equal to the state's. It's not to be used as an investigative tool, which is the intent here. I think that it's important to note that the relevancy determination or the materiality determination here, they don't have a basis for which they would be able to access this evidence. As the state points out, as the court pointed out, it's not a permissive way to impeach the credibility of something to say that you lied at another instance. That's like per se black letter law, not a permissible way in which you can impeach someone's credibility, to say you must be lying now because you lied at a different instance. Moreover, when we look at to whether or not these types of behaviors are at all relevant to whether or not they occurred before. They're not. The issue here is whether the defendants took actions. And they're going to allege, well, we had some knowledge about this child, knowledge that they, for the most part, did not seek any type of professional help for, did not document these types of behavioral things in a way that is consistent with the allegations that they're making now. And to say, well, he had subsequent problems, so that means what we're saying was true. That would not be relevant because the defendants would not have knowledge of it. It would not have impacted their decision making, and so it therefore cannot be a rationale for their behavior. To say that he went in a bucket because, we know that's true because there were subsequent bathroom problems, he went in a bucket because he was locked in a room that was dark for hours at a time without access to any facility other than a bucket. His parents expected him to go to the bathroom in a bucket because there was no other option. And to say that that's because of a bathroom problem is a gross misstatement of the reality and the facts. So based on the fact that, one, it's a constitutionally protected private type of information, there is no basis, and it is not a relevant inquiry. Now, Ms. Marshall got up here and said that, there's false allegations, and so now we need to say there's other false allegations. There's a 4th DCA case on point. I did not cite it because I didn't realize that that was their argument. It's Pantoja versus State. It's a 4th DCA case. It has to do with a prior false allegation of sexual abuse. The 4th District Court of Appeals found that a prior false allegation of sexual abuse in a child sexual abuse case is not a permissible way to impeach someone because there's specifically enumerated per statute ways in which we can challenge someone's credibility. And a prior instance of lying is not a permissible way in which to do it. And so based on all of that, we would object. We think that there is no legal basis, and we also, the child himself objects.
Okay, so before you sit down, let me have you address the question that exists in my mind. With respect to the confidentiality and the privilege issue that exists with respect to both medical records and patient, psychotherapist patient records, what's your take on whether the court can protect that information through an in-camera review and dissect what is privileged versus what may be discoverable?
I think that that should be at the very least. Like, there should be no instance where it's wholesale provided to the defense. However, I think if they have not established their threshold burden, then we don't even get to the step of where there is an in-camera review. These are subsequent records that are unrelated, and there's not a mechanism for them to enter in.
Okay, so my present take on this is this comes from the last time we had argument on this, is to some extent, the defendants are, my perception would be they're engaging in a fishing expedition. But Ms. Murad comes back and says, no, Judge, it's not a fishing expedition. We know about these things because we gained information, either from the parents themselves as the guardians or through the juvenile proceeding. So they're not operating in a complete vacuum of lack of information, which is kind of the sine qua non of a fishing expedition. They have some things that they think are going to be reflected in this, which gives me a little bit of pause because it's not simply the classic, we don't know what we're throwing the line in, we don't know what's going to come out. On the other hand, I am concerned that when I look at the cases that talk about the level of presentation that the state has to make to show materiality, that the defense has not yet reached that level to show materiality such that I would even have to undertake an in-camera review. So respond to Ms. Murad's argument that, Judge, it's not fair because we may not be able to reach that level because we're being precluded and the state's objecting at every turn when we try to bring in evidence that we would rely on to show the materiality of the information to begin with. How do you finesse that argument?
Well, I think that First Stevens directly addresses that is that's the burden. There's a burden that they have to establish materiality, and it's an evidentiary burden which they have not met. And yes, it does create a situation where if you don't know the information, you cannot go on a fishing expedition. To say that they know some of this information through their participation in the dependency case, I think is incredibly problematic. And some of that rationale or some of that argument is the same as why we protect the psycho patient parent privilege, right? Like a child gets to, we're in the dependency case, we're trying to operate, the child was removed because it was not in his best interest to be with the parents. Their parental rights have subsequently been terminated as a result of their actions towards this child. And so now, to allow them to use their access to a proceeding that was instituted by the state to be in the child's best interest, to then use what they gleaned from that proceeding against the child, kind of goes against the idea of why that proceeding was there, right? We had people that were not fit to be parents of this child, who the state had to intervene. Per statute, they were able to participate in a confidential proceeding, who then want to use the things that they gleaned, actions that were taken in the best interest to help that child in good faith, to use it against the child to protect their own criminality.
But isn't you just the last to protect their own criminality? But I mean, it's a reality that the state has brought charges against them, and that they have, obviously the constitutional right to defend themselves. They're in the unique role of having been the parents, so they're going to know knowledge and about things that no one else but parents would know. I have some trouble seeing how that type of information would be protected, even though it might have been disclosed in a juvenile proceeding. So help me out with that
It's
aspect.
important that it's subsequent, Your Honor. They're not charged with conduct subsequent to his removal. They're not charged with things that occurred to him after he was placed in the custody of DCF. And so that has no bearing.
So let's focus on this. So it's all subsequent in terms of the records you're seeking. So Ms. Murad, she floated a question out there that she intended to ask at the deposition, that she may ask the victim, has he had any discipline or done things wrong while he's been in treatment, and that she surmised you may object to that. Let me hear your position on that, because my view is that there's a difference between conduct-related questions and treatment-related questions and discovery. So you may disagree with that. What's your position?
I think I disagree to a certain extent, and I certainly don't want to provide the court an advisory opinion, because I don't know what the question is going to be, what the context of the question is, and also the impact on the child. I'll be honest with you, there's extreme concerns that what happens today is going to be extremely detrimental to the child for him to have to undergo the deposition. It's been expressed to me by him, and it's been expressed to me by people that are involved in his mental health. So it's going to depend on what's happening in the deposition and how the child is responding to it. To the idea that behavior is somehow exempt, I think we have to remember that the confidential medical treatment that he is undergoing is related to behavior. So it's like if you go into a doctor and you report a stomach ache. The stomach ache in and of itself is not a medical diagnosis and treatment, but it's part of your medical care. And so depending on the situation, absolutely, behavior or conduct in the context of this situation could be confidential medical information.
So would you argue that it doesn't make a difference, Judge Coates, because even if there's a difference between conduct and documents and discovery related to treatment, it occurred subsequent, so it's not material, whether he's been in a disciplinary proceeding subsequent to the facts that underlie this case, it's just not material.
Absolutely, and I think that, it could be harassing and detrimental to go through everything a child has done wrong in the last year since he's been removed from his parents, when it has no bearing on the actions that his parents take towards him, for which they are criminally charged.
All right, anything else?
No, Your Honor.
All right, Ms. Herndon, do you wish to add anything to what Ms. Coakley's
I'll just be
spoken to?
very brief, Your Honor. On behalf of the child, he does object to the release of any of these records. I think their argument alone shows that they don't know if the records are relevant. They're saying, we think that there might be something there, but we don't necessarily know. We have some records that the parents were able to get when they were participating, but that's just their argument. They're not bringing those records there today. They have no one here testifying that that is in fact the fact. I would also state that the things that they're saying as facts, I would dispute as actual facts of things that have occurred in the confidential dependency proceeding. Also, I think their subpoena is overbroad. They're asking for all of the behavioral, educational, and medical records for the child, which I still think, these are psychotherapist patient privileged records. He's in a mental health treatment facility. I think you can't change the name of them and say that they're no longer psychotherapist patient privileged records. So I think the subpoena is overbroad. If they're looking for something like incident logs, well, then maybe that's not something that should be protected and they should be entitled to, but they're not asking with that kind of specificity. So I would just say that he is a child. He still enjoys a right to privacy under the statute, under the Constitution, and for those reasons, we would object to releasing the records.
So before you sit down, address with me your position with respect to that subset of information that might be otherwise confidential because it's information related to the medical treatment of the child, but that the parents nonetheless possess it because they were the legal guardians and obtained the information, properly as the legal guardians. So does that impact the parents' ability at all to use the information they obtained regarding their child's medical condition, which would otherwise be privileged and confidential from the standpoint of the child, but the parents are in legal possession of it?
I still think that they are confidential records, and I still think that they obtained those records in a confidential dependency proceeding, and also they were subsequent to the offense with which they're charged, and so they're not relevant.
Okay. Anything else?
No, thank you.
All right, brief rebuttal, Ms. Murad, and then I'll rule.
Thank you, Judge. I have a few responses. First, this idea that, I just think the state and Ms. Herndon are sort of conveniently missing over this idea that the court can review it ex parte. I know the court questioned Ms. Coakley about it. In this two cases that the state cited, Jackson and Stevens, and I'm quoting Stevens right now, which is 288 Southern 3rd, 104. It's a 2019 case out of the 2nd District, and it cites to Jackson, which Ms. Coakley mentioned as well. We recognize that it may be difficult in certain circumstances for a trial court to properly evaluate whether a defendant has met his or her burden of establishing that the requested information is material to the defense without first revealing the information itself. But, quote, the rules provide a mechanism for a defendant to make a showing of materiality without revealing privileged or protected information. Rule 3.220 sub m sub 1 provides that any person may move for an order denying or regulating disclosure of sensitive matters, and that the court may consider the matters contained in the motion in camera. And then it goes on in that paragraph talking about that. So I think there is a solution here to this question of materiality.
So what evidence is the defendant presenting today that establishes materiality? Because as I read the cases, there has to be evidence presented establishing materiality.
So I'm happy, Judge, to provide the court with the records that we have thus far. I would have to print them out, and so if we can do a status check on Monday, I'm happy to provide that. And again, I understand that this...
What records and where were they obtained? If they're records from the juvenile proceedings, I don't think that can suffice.
So they're not records from the juvenile proceedings. I understand, and this is where I'm getting a little frustrated with the state conflating this. We are not disclosing information that happened in court and we only knew it through court-ordered suitability assessments or court-ordered. There are medical records when the parents' rights are intact. They ended up surrendering the child to the department. Prior to that the parents can give, and this is what we did, we sent a medical release like we do in any of our cases and got records back.
Yeah, and I don't have any real issue with that, but I don't see how that gets you to, because it seems to be a big leap to argue that because parents were able to legally obtain the medical records, and it's a matter of law, they can do that as the guardians, that somehow entitles them now to be able to get it now post-charge medical records and psychiatric records of the child. What's the leap? How are you going to bridge that gap?
I think part of the issue, Judge, and it's interesting Ms. Herndon mentioned this, I'm happy to narrow the subpoena to something like incident logs. I don't know that that's why I did behavioral records, right? And I'm happy to take medical out of that.
So I have to make a finding of materiality. So, and discovery has to be reasonably calculated to lead to discovery of admissible evidence. So give me just a hypothetical of what you think would be in the incident logs that would be admissible evidence in the trial that you could use properly and not be improper character evidence or otherwise inadmissible, that would somehow justify the discovery of those items to begin with, because I'm having trouble seeing how they would even be remotely admissible in the criminal trial.
So though the state is right that specific instances absent a criminal conviction of dishonesty or something like that doesn't come in, under 608, reputation evidence or opinion evidence can come into evidence. So if we have records that show a pattern, we can then talk to witnesses at those facilities to see, okay, is there a reputation of dishonesty that we can establish? I don't know, Judge, if I will be able to do that because I don't have access to those people. What I can say is that Ms. Marshall and I participated in staffings while the parents still had the right to learn the medical information of the child. And I know, and I suspect the state will object, while he was at Suncoast.
Your Honor, to anything that was part of the confidential medical and the dependency case. I will also say that these records have not been disclosed in discovery that she's indicating are going to be the evidence in this case. They have not been disclosed to the state or listed in discovery. The state has never seen that.
Okay, all right, continue with your argument.
So based on information that we've learned that is not part of, that the parents had the right to know, I believe that there will be information
that will be relevant to this case. And the reason I think that is, first, the credibility of the witness is always at issue. And I understand there may be something with prior bad acts, but if the child is making inconsistent statements, that may be something that the defense is allowed to impeach on. Reputation evidence under 608 is admissible. For example, and I understand what the state's position is regarding the room and the bucket, but the defense is entitled to present a theory as well. And so us just saying, or a client just testifying, oh, this is a problem that he had. In fact, his sister, elder sister, said in the CPT interview that in, I think, Arizona, his room always smelled because there was this sort of consistent issue of using the bathroom in the room. But then she said, well, that's at least what my mom told me. So the credibility of our clients is at issue here, and the reason that they did the things that they did, which the defense will not suggest at trial and is not suggesting today were necessarily appropriate, we have to establish our client's intent. And part of the issue is that this child has an attachment disorder that was in utero. And so we can't do that without looking at the records and understanding, okay, is there something we can give to an expert to show that this is in fact what the issue was? Again, it may not come into evidence at trial, but I do believe that we have enough for materiality. Now, I would be remiss to say the Hunter hearing example I find very interesting because I have never met a defense attorney that has won a Hunter hearing. We lose them every time because
the
the
case
state.
I read, apparently the state loses them as well, though.
Just in those cases, Judge, because I have yet to see it happen. Those are the 3 cases where it happened, and I don't know if they were in this courthouse. But, you know, the state often does get to have, and I don't disagree with Ms. Coakley that the state's investigative powers are different. They have a burden to prove a case. But we have a right to present a defense. And I do believe that there is a narrow way in which this subpoena could be issued. I'm happy to work, if Ms. Herndon knows more information than I do, to narrow it to something like incident logs or something that would not disclose to us inadvertently psychiatric or medical information. The court could review it ex parte and could only give the defense what the court believes is appropriate. And the case law that the state cited addresses this issue because we are in a chicken and egg situation. We can't tell the court what we don't know, but we, I believe, have enough to from the discovery that we have and from the records that our clients legally obtained while they had parental rights to believe that there are going to be some issues that may be admissible at trial. And maybe they're not. That's for the court to ultimately determine. But I do believe that this can be narrowly structured to still give the defense the ability to actually effectuate due process in this case and allow the child the privacy rights to which he is entitled. And I'm happy, again, to narrow the scope of the subpoena to something like what Ms. Herndon said to try and get that information.
Okay. All right, so the court's ruling is as follows. I'm going to sustain the objection with hopefully what will be a detailed explanation that will provide guidance to both sides. I find that the objection is well-founded for a number of reasons, and let me address them just off the top of my head as they come to me. The first one is that I do think that the victim is entitled to the constitutional right of privacy and the protection of his medical and psychiatric records. Because of that, the court also concludes that any objection by the state to disclosing what are otherwise confidential privileged records would run counter to the Constitution, but also run counter to the various rules of evidence that protect, especially what I've mentioned previously, patient psychotherapist records. In addition, the court notes that the difference between the investigative powers of the state versus the defense, and the court also makes reference to the fact that any discovery is supposed to be reasonably calculated to lead to the discovery of admissible evidence. In order to get at information like this, the cases that I've read thus far guide me into the conclusion that whether it's the state or the defense, there has to be the threshold satisfaction of demonstrating materiality. At least based on the cases that I read in preparation for this hearing, that those line of cases suggest that there must be evidence presented to establish the materiality, and the court can't simply rely on argument of counsel. So because of that, I find that the defense has failed to establish materiality because the court received no evidence in this proceeding. Now, that part of my ruling is going to be without prejudice if there's additional evidence, for instance, as you mentioned, Ms. Murad, in the deposition that it's to occur, if there's evidence there that could be submitted to the court to establish the potential materiality of information that might be subject to discovery, then the court would obviously look at that upon subsequent motion. Even if materiality is established, however, I don't think that materiality satisfaction necessarily gets you to overcoming the confidentiality that attaches to medical and patient psychotherapist records. That being said, I haven't reviewed the documents, and based on my general experience in reviewing medical records and psychiatric records, sometimes, not often, but sometimes, there are parts of those records that may not actually be part of the medical diagnosis or treatment or the psychiatric diagnosis or treatment. Sometimes the psychiatrist will state, no, it's all related to that, and so that usually accords very close to carte blanche protection of those types of records. The reason I point this out is the incident logs, for instance. That may be an area that could potentially be subject to discovery, but even then you'd have to establish materiality and convince the court that it's something that would reasonably likely lead to the discovery of admissible evidence. I'm not convinced by the presentation today because everything that's been raised to me today and argued seems to me to fall in the line of improper character evidence that would be submitted. But I won't say never in this instance, and I won't say that at least the cases, they don't convince me that there's no way to protect the confidentiality and privilege that attaches to the documents by a trial court's review of documents in camera. So I'm not taking that off the table at this point. I'm just saying we're not at the stage where I think that I can even legitimately engage in an order or enter an order that says I'll do an in-camera review, because I don't think that the materiality prong has been established here. I will tell you that I believe absolutely that the medical and patient psychiatric records are going to be privileged. So if this is revisited by me at all, it's going to be very limited and narrow in scope as to the only aspect of those documents that would somehow not be part of the medical treatment and diagnosis or not be part of the psychiatric treatment and diagnosis. So at this point, for the reasons I've stated on the record, I will sustain the objection without prejudice to renew the issue by the defense if they come up with evidence that they can actually submit to the court. I also want to say that I'm not going to rule in advance on any objections that may be made by the state as to any questions that the defense may ask. However, I will tell both sides that I think that there are questions that can be properly asked of a testifying defendant in deposition or victim in deposition that can be asked in a way that they don't violate the medical confidentiality or the patient psychiatric privilege that exist. Relevancy objections in a deposition are generally discouraged because of the broad scope of discovery that generally applies. So those objections are going to be made by the state with some degree of caution, or should be made with a degree of caution, because those are, at least in the discovery context, are generally frowned upon if there's any articulable basis the relevancy of the question. So that's all I'm going to say on that, and I'm sure that based on the deposition that's going to occur, I'll probably see you folks back in front of me addressing specific objections. So that's the court's ruling. Anything else I need to address at this point? So based on the objection, the subpoena and the notice, the subpoena would not issue at this point unless and until there's further order to the court.
Understood.
Okay?
And I think the last issue is the Williams rule issue.
Okay, so let's hear from Ms. Coakley on that. And the argument that I've read your submission on the Williams rule issue. Explain to the court what happened with the September 1st hearing. It wasn't reset, and if not, why? Because if we moved it, because I'm obviously unavailable tomorrow, my expectation would have been that it would have been reset.
We just didn't get in to reset it. And I just want to I want to apologize. This was my mistake, Your Honor. I'm not saying because the September 1st date got reset that I had this on my calendar in a way that was confusing, and that was inadvertent.
But you make the point, it's a fair point that the 5 days was set with reference to the hearing that now doesn't exist. And so it does create in my mind, well, is that 5 days a deadline, or is it something now that's going to change if the hearing's reset? So that's why I asked the question.
So we had trouble finding a date to come in, and then I believe we were going to come in and address it at the most.
So there was an attempt to reschedule, it just was not successful?
Yes.
Okay, all right.
Via email, Your Honor. And then we had a motion to suppress date, and then it got set for the Monday date. I unfortunately, last Thursday, had to go out of state for a funeral. And so that's why I wasn't here on Monday. I did intend to file it by Your Honor's deadline. I just misread my calendar, and the way that it was notated when I read it, I thought that meant that the date was this Friday. It was honestly my mistake. I do apologize. I think
And was there a written scheduling order?
No.
It was just on the record 5 days prior to the Williams rule hearing? Okay, which was originally set for tomorrow and has not been rescheduled? Okay, so, all right, so Ms. Murad, your position on that, and address this for me because this is what grips me here. Especially the argument that the state makes is that the rule says that they have until 10 days before trial to submit their Williams rule evidence, and I obviously narrowed that in this case in order to facilitate a productive Williams rule hearing. But I'm concerned that I tied it to the 5 days before the scheduled Williams rule hearing, and the Williams rule hearing gets rescheduled. So it seems to me that logically looking at it, that date, the deadline to submit the Williams rule evidence probably went by the wayside along with the the cancellation of the hearing. Why isn't that a reasonable approach or thought on that?
So I emailed, and it was very late last night, I apologize, a motion to strike. And so I have transcripts attached to it about what exactly the court said. We had a conference call with Ms. Coakley probably Wednesday or Tuesday, and it was regarding other matters in the case, just sort of scheduling and, offers and stuff like that. And in that call, I mean, again, it's not recorded, it's not written, this is my recollection. I think it's Ms. Marshall's recollection too. Ms. Coakley said, I know I need to file, I'm going to file a Williams rule notice. We didn't know the substance of it. And I know we need to do it by Friday. So that's the only thing I can say. The spirit of me requesting the scheduling order was for the purpose of this case actually going to trial on September 29th. So my position is that if there's not an order, if I'm ordered to do something by a judge and that order is not rescinded and I don't follow it, I get in trouble. So,
That's a good position to hold. It's a good way to proceed.
So, I just think that that's my position, but I put it in writing. I understand that this is really discretionary to the court. I don't think there's case law that really supports one way or the other. What I can say is that in federal court, if you miss a deadline, you don't get to file stuff, and that includes.
The question I have, it's really the $64,000 question. Was there a deadline if the hearing on the Williams rule hearing was canceled? And that's really the question I have. Granted, if we were having the hearing tomorrow, she missed her deadline, and then she'd have to be showing good cause for why she blew the deadline. But I have a fundamental threshold question as to whether the deadline still exists.
Yeah, and I think the court, that's a determination for the court, right? Of course, it's sort of an interesting, in most circumstances, I would say we're talking about minutia, but I do believe that in this case, we are just trying to.
I don't think there's anything such as minutia in this case, based on the arguments that I've had.
Fair enough.
Everything is significant.
So that's just my position. It's in writing. My belief is that if a court orders something and doesn't rescind the order, then that's the date that it needs to be done. My understanding from our conversation with Ms. Coakley was that she was aware of that, and I think she's admitted as such to the court. So I think there was an understanding that it's due on Friday. And again, now that I'm in private practice and for federal court, if you miss a deadline, you don't, even as a defense, the judges doesn't hear your motion in limine. They just say no.
Yeah.
You're standing there like this would never happen, you know, that we're not used to that.
That's why a lot of attorneys in our community don't like to practice in state court. It can be very harrowing.
Right, but so I think that, you know, in the feds, that's what happens. In civil court, if you miss a deadline, you get a default judgment. So there are, you know, deadlines are there for a purpose. And so if we just keep moving them without requests prior and good cause shown prior, I'm not sure what the point of them is. And the spirit of it was, Judge, I want to make sure this.
And I don't disagree with a thing you've said, except I'm not at the point where I think there was a deadline that was missed. You're saying exactly how I used to practice. You make your deadlines, you meet them, and you go on. But there has to be a deadline, and that's really what I'm struggling with, as to whether there was a continuing deadline that existed. Anything else, Ms. Murad, on that point?
I have one thing, to suggest that I'm intentionally misleading the court, or I've suggested anything other than it was an honest mistake.
I didn't get that from her. I don't think she intended, I didn't get that.
And Ms. Murad also said that there's no cases on point. I have provided the court with 2 cases that are directly on part, Gardner versus State, which is 821 Southern 2nd, 1220, as well as State versus Palio, which is 601 Southern 2nd, 1321. Both of those involve cases where, despite the Florida Rule of Criminal Procedure requiring a 10-day notice, the state failed to provide any notice, filed the notice pursuant to the rule. The court in both those cases found that the defense has the burden of establishing prejudice before that evidence should be struck. And so there's no evidence of prejudice here, so I don't think that there's a legal basis. I do apologize, it was a mistake.
All right, so let me ask this, because I'm going to grant the state's motion to submit their Williams Rule evidence, but there needs to be a hearing on it. And what about Friday, September 8th? Are both sides available?
I'm
That is
available.
the only day in September that I cannot move anything around. My sister is in town from England. I'm really sorry. It is the only day. I can make everything else work.
Because I'm going to give you a Williams Rule hearing in advance of the trial so that this does not result in any delay of the trial. So let me work toward some additional dates.
Your Honor, I'm out of town the following Monday, Tuesday, and Wednesday, which are, I think, the 11th, 12th, and 13th, and then otherwise I'm available.
How long would this hearing take?
I don't think it'll take longer than an hour, 45 minutes.
I think it will take longer.
So how long do you think? I err on the side of scheduling more time than is needed so that we complete it. So you think twice as much time?
I mean, just us talking today took an hour and a half, Judge. So I think we originally scheduled it for 2 hours. I suspect they would need to have the child testify and maybe the older sister, and then we would have cross-examination. So I would ask for at least 2 hours if the court has an afternoon.
So here's what, I have a trial starting on the 11th. I don't know how long it's going to be, but I think I'm probably okay if I scheduled this for the afternoon of the 14th, from like 1:30 to. That's a Thursday. Yeah.
We have the deposition that day, but we can move it because I think the state's available on the 15th.
And I can be flexible. I can set it at 1:30, or I can go to, to 2 to 4, or 3 to 5.
So I have jury duty that day, but if the court is willing to assist, should I go beyond noon, I can definitely do the 14th. For instance, I had a hearing I absolutly had to.
Attorneys never get picked
She's
for
not
jury
trying to
duty,
go to
right?
jury duty. She's one of those.
Well, I can do whatever I can do to assist you in not having to appear for jury duty, because this is a very important hearing and a very important case.
Then I'm available the 14th.
All right, so,
The 14th in the afternoon is fine. The Williams Rule hearings do not require evidence. Hearsay is admissible. We'll deal with that. I don't know if I will provide live testimony, but
all right, so I'm going to set it on September 14th at 1:30, 2 hours reserved. Now, I'm telling both sides there's at least a possibility I might have to move it a little bit later in the afternoon, depending on my trial. I don't think so, though. I'm setting it at a time when I think at the worst, the jury would be in deliberations, and we might have to break briefly to take the verdict, but I think we'll be fine. So The motion is granted. The court will hear the Williams Rule hearing on September 14th at 1:30, 2 hours reserved. Anything else that I need to address before we conclude? Now, we have the trial coming up on the 29th. Are there any pending motions in limine or evidentiary issues that I'm going to need to look at or decide prior to the start of trial?
There is going to be a motion eliminate from the state, Your Honor.
I expect we will have one too, I just don't know what the substance will be.
So as soon as you know, well, one, I would say file it as quickly as you can so that you can start working with my judicial assistant, because I would love to have the motion to eliminate obviously heard prior to the start of jury selection, so everybody knows where you stand on the evidence. So that's item one. Item two is there anything to be gained by the court scheduling a final plea conference or rejection colloquy prior to the start of trial? I don't even know if there's an offer outstanding. All right, so there's nothing to reject, so I don't need to do a rejection colloquy. You both tell me, would you like to have one more time to get together in terms of a final plea conference prior to the start of trial?
So I
So-
think that if the state makes an offer, they'll make
So
one.
the answer is no. If something changes, you'll let me know, and you'll come in very quickly if something changes. So we won't have anything on the docket. So right now, we're looking at the Williams Rule hearing, and we're looking at the start of jury selection on the 29th. Those are no further dates are set by the court at this point.
Could we set one status date in a week, Judge, so that the state can advise which trial will be going first? And the reason I ask that is.
I'm fine with that. I'm fine with that. We'll set, I assume you have no objection. You're out the,
I think, is it the 10th, 11th, and 12th, or 11th, 12th?
well, I'm going to set a status check on the morning of the 14th as well. Is that sufficient?
Can we just do it on the 14th can we just do it at 1:30?
We can do it on the 1st.
I live in Miami, and I have to book an Airbnb for this, which I'm happy to do.
So are you available Friday, the 6th,
Yes, Your Honor.
or the 8th?
I am.
If the 8th's better for you, Ms. Murad, I can set it for 8:30, September 8th.
That is the one day I'm unavailable.
Oh, that's right, that's the day you're not available.
But she can be here.
I can be here for that and then.
Okay, so she can cover, because all you need to know is which case is going to go
Right,
next.
exactly.
All right, so I'll set it for status check on Friday, September 8th. That'll take care of that. Because you look concerned that the 14th might be too late to know?
Yes, Judge.
Yeah, all right, so I've taken care of that. Okay, anything else I need to address? All right, court
For
is,
the record, the Williams Rule notice was filed this past Monday, Your Honor, so it has been filed.
okay, all right, good enough then. All right, court is in recess.